I think Judge Lester is a good writer. And I'll have my comments on the order after, but let's just read some of the good writing out of the center of this, shall we? Under any definition, the defendant has flaunted the system. Counsel has attempted to portray the defendant as being a confused young man who was fearful and experienced a moment of weakness, and who may also have acted out of a sense of betrayal, quote-unquote, by the system. Based upon all of the evidence presented, this court finds the opposite. The defendant has tried to manipulate the system when he has been presented the opportunity to do so. He is an adult by every legal definition. Trayvon Martin is the only male whose youth is relevant to this case. It's the only age designation that has a legal meaning in this case. The defendant has taken courses in criminal justice with the intention of becoming a police officer, an attorney, a judge, or a magistrate like his father. He has been arrested before, having entered and successfully completed a pretrial intervention program. He has also obtained an injunction and has had an injunction entered against him. The injunction against him has obviously been dissolved at some point for him to have validly obtained a permit to carry the firearm used to shoot Trayvon Martin. That was interesting there. He has also had the wherewithal to set up a website to collect donations to help defray the cost of his defense. Thus, before this tragic incident, the defendant had a very sophisticated knowledge of the criminal justice system over and above that of the average law-abiding citizen. Moreover, any sense of quote-unquote betrayal would be unreasonable. He was cooperative with the Sanford police in that he did give numerous statements upon request. The state notes that his stories changed each retelling, but on the surface, he should be deemed to have been cooperative. However, he clearly understood that he was being investigated for committing a homicide, and while he believes that he was justified in his actions, there has been nothing presented which indicates that he was misled into believing that he would not be charged with the crime. Contrary to being betrayed, the defendant has received normal, reasonable treatment and was granted reasonable bail. So other parts of this, he starts off talking about, they're having the mini trial, and he says the actual question before the court at this time, the questions are, is the defendant entitled to bail when he presents false testimony at a prior bond hearing, and what recourse there is when the defendant has shown blatant disregard for the judicial system. The interesting thing there is, that he goes on to say basically that Lester would like to deny bail. He goes so far as to say he disagrees with the appellate judgment, but he quotes some opinion that says that lesser courts can disagree, but they are duty-bound to follow the appellate decisions, and that's why he let Zimmerman out. It's pretty clear. He says the evidence is clear that the defendant and his wife acted in concert, but primarily at the defendant's direction to conceal their cash holdings. Adam McGill, the defendant, I'm skipping through, I'm not doing it totally solid here. Adam McGill, the defendant's forensic accounting expert, admitted that one interpretation of the defendant's actions was to hide money, but he also stated it was not a very effective way to do so. The defendant also neglected to discuss that he had a valid second passport in his safe deposit box. Now, I saw somebody at the Conservative Treehouse, I think it was the blog owner, that was going, that was all explained. Omara had it for 3 weeks in his briefcase. Well, no, that's Omara falling on a sword, and you guys aren't even thankful. You all want Omara's head. Because George said, hold on to that. He didn't say, let's turn them all in. He said, hold on to it. So another thing on that, too, is not only did he tell Shelley to hold on to that, but all George had to do is take the stand and give that excuse to the judge if that's what he believes. You can't just say there's an excuse out there. The judge, even stuff the judge has seen, his expertise is to know how to use reasoning and reason, use logic and inference only from the evidence that is actually before him, depending on the criteria of the particular hearing and situation that's going on in the court. So, if George would have had to testify, well, my lawyer had it in his, briefcase for 3 weeks. And if Omara said, yeah, I did, even if it was a lie, the judge, because of that respect thing, would have said, okay, well, I'm in the habit of giving you the benefit of the doubt on these sorts of things. But George didn't even try. He didn't even try. Notably, together with the passport, the money only had to be hidden for a short time for him to leave the country if the defendant made a quick decision to flee. But for the requirement that he was placed on electronic monitoring, the defendant and his wife would have fled the United States with at least $130,000 of other people's money. He said that would have been reasonable for him to find. He says it doesn't matter if they spend it, quote unquote, responsibly. He talks about he lied to his lawyer. He says the court was influenced by its concern that adopting the third district's view would leave the judiciary, the state, the defendant without ascertainable criteria, precise standards, and procedural protections presently existing in the comprehensive statutory scheme and rules, and thus potentially run afoul of the defendant's constitutional right. Now, and this is he's quoting the fourth district's opinion that an appellate court went with, and then this is where he says this court disagrees with that legal conclusion. However, this court recognizes that, quote, it is free to disagree and express its disagreement with an appellate court ruling, but it is duty bound to follow it. Then he says, he points out he hasn't exercised his contempt powers, and he goes through the criteria for bond, the nature and circumstances of the offense charged. The defendant is charged with second-degree murder with the firearms of an unarmed 17-year-old juvenile. Remember those. He's putting the things that are considered tip of the iceberg important there. The weight of the evidence against the defendant. That the defendant shot and killed the victim is virtually undisputed. You guys are always like, the state has to prove their case. Yeah, the main thing is that you killed somebody. The only issue is the viability of the defendant's self-defense stand your ground claim, which he talked about that George Zimmerman's own testimony not being evidence. He's presented no evidence of his actual innocence or that there was self-defense, which is the same thing in this case. Defense counsel chose not to present any testimony as to matters associated with why the financial transactions were structured as they were. All George had to do was get up and go, well, yeah, I was scared of this. I felt betrayed. He didn't even try to repeat O'Mara's defense of him or have his own. Instead, defense counsel argued for the court's consideration that the defendant's youth as a 28-year-old man and his fear confusion were the explanation for the defendant's participation in the presentation of false testimony. The court still has yet to hear any sworn testimony as to the circumstances associated with the fraud upon the court. The defense accountant was just a recapitulation of what happened, things we already knew. Is that it? Didn't highlight anything else yet. That's it. So the conservative treehouse is all turned on Omar now, and they're like, he's got to get a new lawyer, and he should be more of a dragon, and I would never care what the judge thinks of my lawyer. He should fight. You know so little about the law. If you think a lawyer doesn't need, and they're thinking, yeah, he wants his respect for his career. No, it's because when he says some little motion like, hey, let my killer out, and hey, this and that, hey, that respect is how come, he's given a yes to those kinds of requests, and he can say, well, on my honor, or hey, well, I'll take his money and put it in a trust, and the judge just trusts that because he couldn't trust George Zimmerman. So Omar is there going, hey, well, I'm going to take the money and do the right thing with it, don't worry about it, judge. And then the judge trusts him with that, and you want to just give all that up. That doesn't matter. And you guys think you should be his attorney. He'd be toast. He'd be in jail for sure. These guys are saying that Omar should come out there and go, quote the press, compare it to what the judge said, and say, look, the judge is being influenced by the press, and that's going to work. Or that they're going to go to an appellate court and spend months rejudging things that the main judge has said, to try to get him thrown out by attacking his character. Now they're attacking the judge's character, Sereno's character, everybody but George Zimmerman. These guys at the conservative treehouse, they put up a picture from It's a Wonderful Life and about when he jumps in to save the guy, and they're like, George would get in there. Yeah, because he's just the kind of guy. But everybody else, all these people, judges and the lawyer, everybody else has a huge character flaws. It's ridiculous. All right. Well, I'm fine with the bond hearing. I think, yeah, I said it too. It's another case of, yes, I was right. Sorry, I was right. I said judges are predisposed to figure out a way to grant the bond. He'll probably up the stakes. He upped the money. He put curfew, no leaving the county. These are all extra impositions. And like myself, he didn't even really want to free him at all at this point, except for that the Florida law, and this is good that we have law that says you have a big predisposition to go ahead and be let free on some conditions before your trial.